Hi, my name is Aditi Ganeshan, and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2021-2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amachand Mangaldas & Co. is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. Today, we have Shivangi Mishra with us. Shivangi is currently a final year student at the National Law School of India, University, Bengaluru, where she was the Meta India Scholar for 2021-2022. Shivangi's research backgrounds include academicians, litigators, and corporate firms whose work focuses on tech policy. Her work on cutting-edge law and technology questions has been published in leading international journals. I'm delighted to have you here, Shivangi, and I look forward to hearing about how you've approached surveillance and freedom of speech in the technology sector in India.
Hi, everyone. I'm Shivangi Mishra, a final year student at the National Law School of India, University, Bangalore. And in the last year, I've had the opportunity to work with the Center for Internet and Society, Bangalore, as my mentoring institution as part of the Meta India Tech Scholar program. My research paper is titled Designing a Multifaceted Panopticon Cell by Cell, India's Move Towards a Surveillance State. And every word in the title of my paper is relevant, and I think it would be helpful if I can take 30 minutes to provide a brief analysis of their significance. So, designing suggests a planned intention behind the architecture. Multifaceted suggests that there exist multiple ways and multiple agencies in the panopticon, and cell by cell suggests that there is not a radical declaration of mass surveillance that would immediately face civil society opposition, but a gradual, seemingly innocuous, and sometimes invisible move that would effectively results in the same. Now, why do I care about privacy? And why I've spent the last year working on this project is I've often been asked as a technology enthusiast that I should not care about privacy. I'm often told that when you decide to post yourself on social media, you give up the right to expect privacy, and that the cost of being the safety of being a woman are surveillance projects guised as safe city projects. And amidst all of this, what bothers me the most is that we are becoming gullible citizens, forgetting to demand accountability. And to get myself and now you to question and think is the very reason I'm speaking about my research paper with you today. The main idea of my paper is to understand how surveillance reshapes state power and reimagines the relation between the state and its citizens. In furtherance of this, I study the emergence of technological innovations for governance such as Aadhaar, CMS, NatGrid, Netra, and Project Insight, to argue that the growth of the 21st century surveillance state is a clear manifestation of India's new constitutionalism, which is the absolute state. I should, however, caution at this juncture that by no means is my study of the various technological innovations exhaustive. And in fact, there are multiple such other projects. A few examples would be the state level Aadhaars, the smart city projects, the deployment of facial recognition technologies and drones, as well as the social media monitoring tenders. Given the time and spatial constraints, currently this is in the form of a working paper. And in my paper, I have used two frameworks to study these projects. These theoretical lenses or models are used to situate the case studies that I will analyze in the next part of this presentation. The first framework is the one being the choice of a public order perspective over a liberty perspective. This is a concept that has been borrowed from Professor Parna Chandra and Pranal Satish's reflection on constitutional choices in criminal procedure. Most choices underlying technological innovations tackle the tension between competing goals of protecting individual liberty and promoting the public good. Often the two options are either emphasizing individual liberty by restricting state power or emphasizing public order by limiting individual liberty and expanding state power, which is the public order perspective. In my paper, I situate the innovations in their socio-political context and argue that the particular strategic timing of their inception suggests that they adopted a public order perspective from the very beginning. The second one being the characterization of the state's move as aggrandizement. This is again a term that has been borrowed from Tarunath Khaitan's idea of executive aggrandizement. I play into the three essential elements which form into the design of capturing state power. The three elements being incrementalism, democratic rhetoric, and systemicity. This characterization of aggrandizement is a borrowed but modified version of Khaitan's idea of executive aggrandizement in developing countries. The sources I've referred to in my paper are journal articles, blog posts, newspaper reports, press releases, government websites, reports and comments, and case laws. And the way I have structured my paper is that the first part outlines the history and evolution of the right to privacy and its eventual conceptualization, as was deliberated in the Constitutional Assembly debates, and then further interpreted by the Indian courts. The second part of it deals with several case studies, with an emphasis on the tax department's Project Insight, given this that even though it has been functional for about 6 years, the individual taxpayer, or you and I, have no idea about its existence. And when we think of a project like that, it's important to recall that how I mentioned that these innovations are seemingly innocuous or sometimes invisible to citizens. In the third part, I discuss the role of institutions such as the judiciary in acting as a check against the aggrandizement of state power. Moving on to the findings of my paper. Now, the right to privacy trajectory is an important development in conceptualizing how privacy was first visioned. In India, starting from the constitutional debates, the shaping of the rights in the courts suggests an antagonistic formulation of the right as against security and state interests. And it's noteworthy to mention that the lack of an explicit reference to the right to privacy in our constitution was not a mere omission, but a conscious decision by the drafters. And shortly after B.N. Rao's appointment as the constitutional advisor to the Constituent Assembly, he traveled the world to meet scholars, judges, and authorities on constitutional law to understand the framing of the Indian Constitution. In his famous interaction with Justice Felix Frankfurter on the incorporation of due process clause in the context of personal liberty, B.N. Rao was convinced of its exclusion, and he believed that an obligation to follow the high standards of due process would impose a high burden on the newly formed Indian judiciary. Consequently, as soon as he came back to India, he excluded all reference to due process in Article 21. And it's his vision of due process that heavily influenced his thoughts on privacy as an offshoot of personal liberty. And the principal objection that he had was that the privacy would conflict with administration of criminal justice and efficient law enforcement in a country as large as India. Now, the background in which these debates emerge is worthy of mentioning for two reasons. First, that it shaped the right to privacy jurisprudence that was to come in India in the following years. And second, in tipping towards the public order perspective as against the liberty perspective, it determined the contours of rights adjudication in India. And in this conceptualization of privacy that has continued to mold the discourse. And now state interests and national security have become ritualistic incantations that construct a surveillance state, which is what we will uncover in the next finding. Now, in this finding, when we look at the socio-political context of these projects, the projects that I mentioned earlier, which are CMS, NatGrid, Netra, Aadhaar, and Project Insight, it can be seen how the timing of the inception of these projects is instrumental in conceptualizing the way in which we view privacy as antagonistic to state interests. Now, CMS, NatGrid, and Netra came as a response to the 26/11/2008 terror attacks, the aftermath of which saw the emergence of intelligence and metadata surveillance systems to strengthen state security. And surveillance was then strengthened through the blurring of lines between law enforcement and investigation. and intelligence. Now, Aadhaar, even the deployment of a system of unique identity, it finds its traces back to a time when national security was endangered. And it actually began in the aftermath of the Kargil War, when the need for compulsory registration of citizens and non-citizens living in India was recognized by a group of ministers. Later on, it was admitted by the National Security Advisor that from intending to wash out aliens and unauthorized people, it became a more development-oriented project. And the metamorphosis of this project after its conceptualization in itself suggests a great deal behind the original intention of such a large-scale project. When we come to discussing Project Insight as an initiative of Central Board of Direct Taxes, it is primarily an information exchange mechanism which was devised to counter the effects of tax evasion and avoidance. However, it accumulates information from a variety of databases, including the social networking profiles of individuals, foreign banks, rental details, vehicle purchases, etc., to check for discrepancies with the declared income of the assessee. As per news reports, sources of information about an assessee include Facebook and Instagram activity that is characterized as lifestyle evidence. Further, the project employs tools to bring all the data onto one platform, essentially creating a 360-degree profile of an individual. Again, this was brought about in response to the 2008 financial crisis. Post the 2008 financial crisis, the global community was facing an economic recession, and there was an increasing need to effectively address tax avoidance on an international level. And it's during this time that in 2010, Britain incepted a similar technology project which had come to light then. According to reports, Project Insight was initially announced in 2016, and it took over 7 years to build it. So it's reasonable to assume that the inception of the project began soon after the 2008 crisis and was largely in response to the economic crisis. The technological innovations that I've discussed, these bestow unlimited power upon the government in matters of surveillance on the pretext of achieving the stated goal of maintenance of law and order. In the case of NatCrit, CCTNS, and Netra, distribution of benefits in the case of Aadhaar, and fair and judicious tax administration in the case of Project Insight. This often results in undermining or even destroying democracy on the grounds of defending it. And the recurring emphasis on national security and state interests is to demonstrate the prevalence of the democratic rhetoric behind the aggrandizement and the design of the absolute state. Along with this, when you look at the weakening of the accountability mechanisms, such as the judiciary and the legislature, this points towards the systemicity in the state's approach. Aadhaar received a sanction without much heed to its inherently surveillance-prone design. And often, extension of these surveillance measures by democratic governments is done through legislative secrecy and opacity, which fortifies them. The concerns are in fact amplified when you look at the recent exemptions for the government use of personal data of individuals under the legislature's recently drafted Digital Data Protection Bill 2022. When I come to the final question, this brings us to some food for thought, some reflections, and some recommendations. What is missing? Is there a need to reimagine the right to privacy as constraints on state power? Or do we need to look at beyond the role of institutions such as judiciaries as guarantors of our democratic freedom? And could revisiting constitutional morality in this context provide a potentially viable solution? And in India, in the post-Puttaswamy era, even though the doctrinal tools to check against the state's potent powers of surveillance exist, the prevalent mode of aggrandizement, the judiciary, may not act as an effective check. These micro-assaults on the individual's right to privacy, as demonstrated in the preceding text, appear only beneficial to the public interest and harmless when they are viewed in isolation. To the extent that the Indian courts refuse to fight these individual battles that either appear too small or too non-partisan, the courts are fortifying the formation of a surveillance state by allowing them to be on the grounds of security, secrecy, and sensitivity, which has been a recurring theme throughout our discussion. And in such a situation, I argue that perhaps an over-reliance on these institutions as sole guarantors of democracy may not be the best approach. There is a need to reimagine the way we conceptualize privacy. And as an approach, I discuss it to reimagine it in the context of constitutional morality, which means not only locating the value of privacy as dignity, not just through explicit references and reading it into the Constitution, but through conscious structures of the government and a conscious design to limit the abuse of state power. As I come to the end of this presentation, my aim in this working paper is not too big. I do not think it can have the effect of dismantling the architecture or creating an uproar. But what I do wish and hope is that through this paper, you and I and everyone who reads about any such initiatives in the news today and tomorrow begins to view these initiatives as not mere episodic harms to privacy, but as constant attempts to undermine democracy. They might seem innocuous, but if we do not act soon, the harm could be immeasurable. With that, I come to the conclusion of my presentation.
Thank you so much for that, Shivangi. And I think you really covered not just the literal policy changes, but also the larger kind of legal and constitutional implications behind them. And I think certainly as I'm not a lawyer myself, those are the sort of angles that we miss out on a lot of the time. So that was great. I am a journalist though, and I think sometimes when we kind of look at how these programs work in India, we tend to become a little insular, and we can tend to get sort of wrapped up in what's happening in India, which is important and necessary. But I'm kind of interested in understanding, are we seeing other democracies shifting towards this? I know you'd mentioned the UK as well. Are we seeing other democracies shifting towards this sort of semi-permanent state of surveillance? Is India unique in this approach? Is there something different about India's approach? Even if other democracies are doing it, is there something different about the way India is doing it? I'm interested to know how we square up on the global front, and feel free to compare if you have to.
Yeah, thanks, Aarti, for that question. Yes, I mean, India is not the sole democracy that is taking these initiatives into question. Like, we have initiatives across the world. One of them I mentioned, which is I think in our Project Insight was inspired from UK's initiative in 2010 for tax administration. So, and like I mentioned in the beginning of my presentation as well, that in this technological era, I do think the governments around the world, democracies around the world, are employing measures that are technologically, efficient. And but however, I feel like how India is unique in this approach is when I talk about how there is a missing accountability framework in here, how we are actually putting in design into thinking through this. Like I mentioned, my paper is titled Designing a Multifaceted Panopticon. How India in my study is unique is that there is thought into how these multiple frameworks in multiple departments can be integrated. And once they are integrated, I mean, the intention could not be that far-fetched that, okay, like it is going to be a surveillance democracy, but it does end up being that. So it is always impact over intention. And when you're thinking about the design and you're thinking about it in isolation, you don't see that it could be that, it could be that harmful. It appears very innocuous. However, when you look at it in, together, that's how it comes across as a design and a manifestation of that design. And that's where we are progressing. And that's what most of these scholars have spoken about. And which is why I borrow from Tarunab Khaitan specifically, which is specifically particular to India, which is the executive aggrandizement model that we see in our country.
And I mean, you went through Professor Khaitan's work while he was speaking as well, but I think in the context of this answer, can you just elaborate a little bit on how it's relevant here? I didn't quite.
Yeah. So Professor Khaitan talks about three particular elements that make us that progress towards the state of executive aggrandizement, which are incrementalism, democratic rhetoric, and systemicity. So he talks about it in the context of state party fusion, right? So which is how the BJP is moving towards. It's becoming how we view state and the party as one. So he talks about it in that context. I have only adopted those elements to bring about it in my context. Those elements being incrementalism. When I talk about incrementalism, it means that you're approaching a step-by-step approach towards it. Like I mentioned, there are particular departments that are moving towards it, right? And when I talk about democratic rhetoric, I talk about how they are constantly using national interests, state securities to infringe upon the liberties of individuals. And when you put these ritualistic incantations as big terms, I don't really know what do you mean by national interests. I don't know what you mean by state interests. How do I counter that, right? And then systemicity is that you begin to weaken all the other frameworks around it, which is like the legislature drafting the digital data protection bill with wide exemptions to the state. So you are weakening all the accountability mechanisms towards it, essentially rendering it like all the force in one particular organ, which is the executive. So that is my idea when I talk about, when I borrow from Tarunath Khaitan's executive aggrandizement framework.
All right, thank you for that. And I think, aside from Professor Khaitan's work, I think it's important to also look at these India-rooted theoretical contexts when looking at these issues of tech policy. I think a lot of the time we end up borrowing sort of older models from, say, the 16th or 17th century, or we're kind of looking at Western models as well. So these contemporary theoretical frameworks are helpful. I just have one more question. You'd sort of spoken about the need to maybe move away from institutional dependence when it comes to privacy, to stop reading privacy into the Constitution, and also to kind of embed perhaps privacy by design across institutions. At least that's how I understood it. I'd be interested to know, like, what does that actually mean in a practical context? Like, yes, in the practical context for the former case, you have a bench of judges sitting and deliberating on privacy, giving you the Puttaswamy judgment and other subsequent judgments. When what you're talking about, what does that practically look in real life? How do you embed this morality across institutions?
Yeah. So thanks for that question, Aarti. I actually had a very interesting discussion with Justice Sri Krishna on this very question. And we had certain differing views. But what we did really agree upon, I think, is that when you locate privacy as dignity, not just by explicit references in the Constitution, but as I say, through conscious choices that we make, through conscious structures of the government, I essentially mean it starts from the very grassroots level of, educating you and I about what privacy is, why it matters, and, dismantling the myths that you might have, as I mentioned in the beginning of that, posting on social media is not like giving up your right to privacy, because, you choose the kind of audience that you might want to cater to. And that is simply not like a trade-off that you would view it as. So I think it starts from the very grassroots level of you and I understanding what privacy is and educating people around what privacy is and how it could take many different forms for many different people. And it goes on to being embedded in the design of conceptualizing these very projects and technological innovations. So when you look at projects such as Aadhaar and projects such as Project Insight, where are the accountability mechanisms that are being built into these very projects? So like you mentioned, the concept of privacy by design, right? So you embody it into the structures of the government, and also embody it in the decisions that we make as like I talked about, when you're weakening the legislature, which is weakening the legislature and the judiciary, which is going to hold the executive accountable for all of the projects and implementations of these projects, you are blurring the lines between, you're blurring the lines between accountability and state power. So I think that is the idea of having privacy inbuilt in, like, from the grassroots level between you and I, to talking about it at the structure of at the levels of the government, as well as talking about it as privacy by design in technological innovations.
All right, thank you for that. And I understand what you're saying, but this is a bonus question, but are there other governments or sort of countries in the world that have been able to do this, at least start? I know it's a new conversation, have started the conversation. I can think of one or two intuitively, but I'll let you answer.
So I do think that I'm actually not sure.
Okay,
No,
then
is it the US? Like,
I
I've
was
seen,
thinking of the EU mostly with the GDPR.
but that's not a government. Okay,
I meant sort of like, are there blocks
government
or like
so you mean like legislations around the world?
yeah, that are kind of instilling this sort of privacy by design.
Yeah, sure. I mean, yeah, like there are legislations around the world that are doing this. Like the GDPR is one of the leading legislations on that. But I'm not quite sure about how much of it has been implemented on ground and how we have seen that being done in technological innovations around the world yet, right? So, like, sure, there is that legislation that exists and that fosters that this everything should be done by using this approach. However, I'm not particularly sure, like if you look at projects like Aadhaar around the world, if they have been implemented with keeping this in mind.
Got it. Thank you so much, Shivani. This was great, and it was wonderful learning about your research. If you're interested in watching more of the videos presented by the scholars on their research over the past year, please check our YouTube channel and our website for more information on that. And do reach out to Shivangi if you would like to learn more about her research or collaborate in any way. Thank you so much.
Thank you, Aarti.